Ask an attorney. Just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now in Tampa. Call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open. And if you have a legal question, all you have to do is to dial the number 877-943-9673. Again, I'm attorney Joe Pippen. Your question can be about wills, trust, probate, trust administration, real estate, family law, personal injury, something going on in your life you need someone else to talk to. Hey, I'm here and I'm glad to help you this morning. And you have a toll-free number, again, 877-943-9673. We're also broadcasting today on Facebook Live, where the law offices of Joseph Pippen has a business page, as they call it, and we're broadcasting on that page, although I will transfer to my other pages after the show. But if you would like to tune in, go on Facebook Live and go to Law Offices of Joseph Pippen. You'll be able to watch the show if you're interested in doing that. Right now, though, you have a toll-free number if you want to call the show, 877-943-9673. 877-943-9673. And again, I'm attorney Joe Pippen, and the law office is open. Had several speaking engagements this week, and during those, of course, we always have a question and answer period. We're at Fleming's Restaurant on Tuesday night and Thursday night, and Humana, in their office, had me come in and speak to their customers and talking about wills and trusts and answering questions. You know, there's always that one question that comes up. I don't understand why my will would have to go through probate. I did a will. I want to then say I've got one son or daughter. I've appointed them the personal representative. I've left them my entire estate. I did all that in writing. I paid an attorney to do that. Why, when I die, must that will go through probate? I thought I was doing something basically to make it easy for them by having a will. Well, doing a will doesn't make it easier for them because now they have written instructions they must follow. But if you die with an asset just in your name, it's going to have to go through probate. Probate is the legal process of getting assets out of a deceased person's name. You can avoid that with a trust because the trust owns the assets and then the asset is not in the name of a deceased person. So it's much easier, I think, for your family, much less costly for your family to, if you do a more advanced level of estate planning to help them make it quicker, easier, and less costly. Let's go to our first caller. Let's go to Rick calling from Florida. Hey, Rick.
Hey, Joe. Good morning.
Rick, what city are you calling from?
I actually live in Stuart, Florida.
All right. What can we do for you?
Well, I wanted to Ladybird deed my primary residence to my son, who's my only heir, and to basically remove the asset from my name and avoid probate when I expire.
Okay.
And my only question is, in doing so, am I able to change that, or say if I wanted to, 5 years from now, roll it back into my name or put it into a trust?
Yeah, I had a conversation with a client exactly along these lines yesterday, and here's what I told the client. Yes, you can do a Ladybird deed. Yes, you can name your son as the beneficiary of your property on the deed. Yes, you can change the deed at any time. You could cancel that deed or change that deed and name someone else, or you could do whatever you want to do. You could sell the property before you die. You can do whatever you want to do with the Ladybird deed, and the Ladybird deed does avoid probate. Is there perhaps a alternative and a better way to do this? And my answer is yes. I would prefer, I would not do a Ladybird deed. I would do a living trust, put the property into a living trust. You can always amend or change the trust. The trust has a beneficiary. The better part to me is that if I have a stroke or become incapacitated, that the successor trustee that I choose can now come in, take over, and manage that property and do whatever's needed to be done with it while I'm living. A ladybird deed, nothing really happens until you die.
Question.
Yes.
As far as, say, when I get older and I want to qualify for government benefits, if I put it in a living trust, does that actually, is that considered an asset in my name?
The homestead in Florida is a non-countable asset. So the homestead does not count as an asset at all, and it's protected from creditors. So the homestead has really no impact on qualifying for Medicaid. If all you had was a homestead, you would qualify for Medicaid. The house could still be left to your son, free from the claims of the nursing home or medical bills.
What about Joe? What about a second home? Like if I had a investment property.
A second home can also be treated as exempt if it's a rental home, or perhaps it's in another state and you put the home up for sale. There's a way that we can orchestrate around also protecting the second home in Medicaid planning. I have a full-time Medicaid attorney on staff. That's all he does is Medicaid. He probably works 50, 60 hours a week helping people reposition assets, qualify for Medicaid. We can usually qualify a person for Medicaid in maybe 60 days, and protect, move assets around. The power of attorneys that we do authorize the movement into non-countable exempt categories. And also, he and I have written a little book on asset protection and Medicaid. If anyone wants that, it's $20, and they can send in for it. And I'll give out my contact information several times during the show.
Great. May I ask one more question?
Sure.
Okay. This whole idea came about because of divorce in my life, and the simplest way to quiet claim the properties into my name was my doing a ladybird deed on both the primary homesteaded property and the income property.
So your wife signed a deed to you?
Correct.
But it's a ladybird deed?
Right. Yeah, correct. I want to have her sign a ladybird deed to quiet claim into ladybird deed on both properties.
It would just be a quit claim deed from her to you, though.
Correct.
A ladybird deed doesn't really come into that transfer during a divorce usually.
Well, it would be. I would probably quit claim it and then ladybird it,
or consider putting it in a trust. I would suggest you at least consider that and have a conversation with an attorney about that.
There you go. Thank you, Joe, for your time today.
All right, thank you. You're listening to Ask an Attorney, all about Florida law, and I'm attorney Joe Pippen, practicing attorney. The law office is open. You have a toll-free number, 877-943-9673. And we have a caller. Let's go to Ruth in Winter Haven.
Hello?
Hey, Ruth.
Mine, that man said that when he gets older, I'm 92 and a half, but I'm old already. But I want to know.
Hey, you sound young.
That's what everybody says. I have a living trust, and my furniture has been appraised once when my husband died 24 years ago. Now, I only have an only child, a daughter, and she knows she gets all this furniture. Is the government going to come in here and do this again, appraise this again, and I pay taxes on it?
No.
That's what I wondered.
Yeah, no, your furniture doesn't go in the trust, by the way, because it's a non-titled personal asset.
But what are they going to do?
Is your daughter, so you have a trust, your daughter can, and you leave everything to your daughter?
Uh-huh.
Your daughter can just come in and do whatever she wants to do with the furniture.
Oh, I don't have to put it in a will or anything.
No. If your will says all my real and personal property to my trust, the trust says 100% to your daughter, so your daughter won't have any trouble receiving everything.
Oh, good. Why did I have to when my husband died? Why did they come in and I had to pay taxes on it?
Yeah, that was in Florida?
Yeah.
Well, what kind of taxes?
I don't know what it was. They appraised all my property, all my furniture.
Who's they?
Auctioneers. And I don't know whether it was the county or what it was.
Who was the personal representative of his will?
Me.
Well, I don't know. You must have had to hire them. Nobody's just going to come do that. You must have had to hire them for some reason.
No, and I had to pay taxes on it. All the furniture. That's why I wanted to make sure.
This was 25 years ago?
Yeah. 24 years
All
ago.
right. Well, I'm not sure what happened then, but I can tell you your daughter won't have to pay any tax. Is your estate under $5.5 million?
Yes.
Okay. You had to think about that for a minute, though, huh?
Yes.
As long as you're under $5.5 million, there's no estate tax.
All right.
The only thing your daughter will have to do is the final income tax return.
Oh, sure. Oh, sure.
So, but I don't think taxes will be a problem.
All righty. Thanks a lot. It's nice what you do.
Thank you very much.
Bye.
All right. You are listening to Ask an Attorney all about Florida law. I'm attorney Joe Pippen, practicing attorney. Phone lines are open. The whole purpose of the show is to be here to help you maybe through some problem you're having. If you have a question, all you have to do is to dial the toll-free number, 877-943-9673. Let's go to Carl in Parrish. Carl, are you there? Don't think Carl is there. Carl, you can call back. Unless you went to sleep and you're going to wake up here in a second, you can call back. My note says Carl has a vendor issue. And I'm not sure what that would be. That's all I know. But Carl, hey, if you can call back, please do. Lines are open. If you have a legal question, can be about just anything. 877-943-9673. 877-943-9673. One of the questions I get at the seminar this week was, are any assets that do not go into a trust? If you create a trust, are there any assets that do not get placed in the trust? And my answer always is, well, a trust is a bucket. You can put whatever you want to into the trust. And are there normal things that don't go in the trust? Yeah, you don't normally put an auto in the trust. You don't put furniture, like Ruth was asking about, in the trust. That's non-titled. You don't put retirement accounts into a name of a trust. Why? Well, the retirement accounts have a named beneficiary. And there's no need to, unless you're going to do a stretch. If you want to do a stretch distribution, which I'll talk about here shortly. Let's go back. Carl is on the line now. Hey, Carl.
Mr. Pippen, I hired a handyman to do a job. I gave him 50% down, and he finished the job. It was $163 total. So I said, well, okay, we'll give you a bigger job. So I gave him a $200 cash deposit. He gave me a receipt, but it's not dated. But I know it was in January because my daughter was here at that time, and she didn't want to hear any noise from a power machine. So I postponed that from January 22nd. And I called him and found out that he's living with his mother in Florida, in Sarasota.
Now, where do you live? In Parrish?
Yes.
Okay.
So he's quite a distance away. And
all right, Carl, let's cut to the quick here. How much does he owe you?
$200.
And he didn't do any work for the $200?
No.
All right. Well, the attorney, if you hired an attorney, first of all, attorney's going to charge you more than $200, so you're not going to make any money if you hire an attorney. That's what they have small claims court for. You can go into small claims court, plead the case yourself. Well, you can go down to the courthouse, get a petition, fill it out, send him maybe a draft copy of it, and say, look, I don't really want to do this, but you're cheating me out of $200, and it's not the money so much as the principle of the thing. So I'm going to file this and go to small claims court. And hope you can just see fit to pay me to save us both a lot of trouble and aggravation. See what happens.
How do I go to small claims court?
You just show up at the courthouse, and they have a small claims court division, and they have very helpful people there, and they have blank forms that they'll give you and maybe talk to you a little bit about.
Okay.
And go from there.
Okay. So that doesn't assure me I'm going to get my $200.
No, but you get a judgment. I mean, maybe he doesn't want to bother with all this and doesn't want another judgment, or maybe he doesn't want his first judgment. And the best thing I can do is tell you to try this.
How about if I report it to the Better Business Bureau? And
you could do that, and he might get a black mark on his name, but he might already have 50 black marks. Who knows?
I don't know.
Yeah.
But he did good work when he did it. Okay. on my first job.
All right. Well, maybe send him a certified letter, shake him up a little bit, maybe.
Okay, I could do that. A certified letter would be written by a lawyer?
No, you try to do it yourself. For $200, you're gonna spend more than you're gonna make out of this deal.
Yeah, so then the post office could send it certified.
Yes, sir.
Okay, Mr. Pippen, thank you very much.
Joe is fine. Thank you. All right, let's go to Mark in Tampa. Mark?
Morning.
Hey, how are you?
Good, how are you doing?
Good.
Got a question. If you sell a house in Florida and you disclose on the documents as is with right to inspect the known problems of the house, as the sellers, are you protected if the buyer decides to, let's say, sue you for the problems that they were aware of at that time if you disclosed it properly?
They can sue you, but I think if you had proper disclosure, then they're not going to have much of a case.
Okay.
So a seller has a duty, even on an as-is thing, I think, to disclose a known problem.
Right.
I mean, if your roof was leaking and it dripped down and made a stain on your ceiling and you repainted the ceiling and tried to hide it, even though you're selling it as is, you still could have a problem there. So it's good that you disclose things, and it's good that was on the contract or and so forth, and they knew about it. So I don't think if they know about it and you sell it as is, there could be a problem.
Is always good to put in as is with right to inspect?
Yes. Yeah, as is good. Good language for a contract. That gives you some protection.
Would you recommend an attorney prepare a disclosure or look over a disclosure like that if it is a house that has known problems?
Yeah, definitely. I would have an attorney look at it, sure.
Okay. So it'd be worth the time then, and it wouldn't probably cost that much to have that done?
No, probably not at all.
Okay.
All right, Mark?
All right, thank you very much.
All right, thanks.
Bye.
Hey, you're listening to Ask an Attorney, all about Florida law, and I'm attorney Joe Pippen, practicing attorney. You have a toll-free number if you want to call the show. We have a few open lines here at 877-943-9673. That's 877-943-9673. Just a reminder, we are broadcasting today live on Facebook Live. And we next week we'll announce a new exciting network that we will be on, where you could watch Ask an Attorney all about Florida law, the show. I mean, the radio show will be on TV on a special network. So we'll make that announcement next week. But if you want to call the show today, it's 877. It's being broadcast today live on Facebook Live on my law offices of Joseph Pippen page. So. And even on that, we have the little phone number, Ask an Attorney phone numbers on the screen where you can call in from Facebook Live. I'd be very excited to get my first call from somebody who just was watching on Facebook Live. That would be cool. That would be an historical event, I think. So anyway, let's give out the numbers. So we'll talk to Phil in a second. 877-943-9673. 877-943-9673. Phone lines are open. Let's go to Phil in Gulfport.
Morning, Joe.
Hey, Phil.
Long-time listener. 2 weeks ago when you had the minister on for the 4th of July holiday weekend.
Yeah, Pastor Whitten. Yes, sir.
Yeah, right. Those are always interesting. I tried to get in, but it was so busy. But the question with all this immigration debacle thing that's going on now, illegal aliens, and my question is about they're saying that the freedom of religion denies people freedom of religion. But does our Constitution cover people that aren't citizens of the United States? Wouldn't that be a freedom of religion? I mean, I don't understand why they're saying it's a freedom of religion if they're not even a U.S. citizen.
Well, anybody that comes to America, I think, whether you're a citizen or not, has the freedom of religion here.
Right. Yeah, but if they're not a citizen in the U.S., how could they be protected under our Constitution when they're not even a citizen?
Well, they have the right if they're not a citizen. I mean, you can't. If somebody from another country that's not a citizen kills somebody in the U.S., they still have to face the court system in the U.S. So it's basically the same thing. You have a right to do. So I think they still have rights to practice their religion once they're here, even if they're not a citizen.
But we probably don't have rights when we go to other countries, though, probably.
Probably not.
Well,
No.
Yeah, yeah.
No, you don't believe what they believe. They shoot you.
Yeah, right. Exactly. All right.
Or cut your neck on the beach on Facebook Live or something, you know. So.
All right, Joe. Have a great weekend.
All right, Phil.
Thanks.
All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we're open every week during this time period, and soon to be streaming live on webeamtv.com. Hey, so we'll tell you more about that next week. So the show, let me give you a little information about the firm. We have a 100-page website. It's www.attypip.com. And we have 20 office locations around Florida. We have 7 attorneys. We have different practice areas. I do primarily estate planning in my practice. We have other attorneys that do family law, real estate law, Medicaid law, some tax law. We have real estate foreclosure defense and real estate transaction law that we do. So we have a variety of practice areas. Had the radio show since late 1984, almost 1985, but late 1984 we started the show in October. So I believe it's the longest running continual show in Florida where people can call in and ask legal questions. Our sole purpose here today is to help people with problems and help people understand laws and try to get them pointed in the right direction. If you would like to call the show, we have open lines right now at 877-943-9673. That's 877-943-9673. Phone lines are open, and we are here to help as many people as we possibly can. If you would like to receive our free estate planning poster sheet, we'd love to mail that to you. This is a sheet I handed out at all my speaking engagements this week. And people, it's a large poster size sheet. There are about 6 articles on one side of the sheet, all about estate planning, explaining trust, avoiding your options in estate planning, explaining the consequences of your choices. All of those things are on the sheet on one side. On the other side, we have our web address, all of our office locations, all of our local phone numbers, all of our attorneys, and more information about the radio show. So if you'd like this, I'd love to get it to you, and we'll pay the postage. So you can request it one of 3 ways. You can call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529. You can email me for it. That's Joe, J-O-E, at attypip.com. Or you can text me for it, 727-667-3967. Again, I'm Attorney Joe Pippen, practicing attorney. The phone lines are open. You can call in and we can chat at 877-943-9673. Let's go to Matt in Tampa.
Yeah, hi. I guess I got a question. I'm trying to build a case of, I guess, a mechanic that's been working on my boat for like the last year, and I recently just got it back, but it turns out I'm missing some parts, and the parts are can exceed over $2,000 there to get this thing together. So what I'm doing now, I'm driving up to Tampa, and I'm going to have an officer meet me at his house because he's working at his house now, and I'm going to have him try to mediate, a resolution or between us. And I would just want to build like a paper trail, I guess, to make my claim in small claims court look a lot better to a judge.
Okay.
And I mean, what else? I heard you just earlier talk about a certified letter. I considered doing this. I don't know if the Tampa Police Department can give me a police report of what I'm going to do here in a little bit. I just wondered, what else I could do.
Well, I would have maybe a mechanic look at it to verify the parts are missing.
Yeah, I've already done that.
And you have that in writing?
Yes. Oh, no, I can get that in writing, though.
Yeah, we'll get that in writing. And maybe the more the mechanic could say in writing, it looks like these parts were removed.
I think you used them to build another engine. This is the kind of shady person this is. And then I actually
Well, the problem would be in this type of case to prove that he took them. I mean, they're missing, but you got to have evidence of who took them and how they. So the more a mechanic can maybe describe how they're removed, maybe they were professionally removed, maybe they're the most expensive part on the engine. That's what if somebody was going to steal them, it'd be somebody working on the boat and they wouldn't know what they were and what the value was. I don't know. The hardest part of your case will be proving that the person that you think took them.
Right.
So whatever the mechanic that does the inspection can come up with, along as evidence, would be helpful.
Okay. I've already done that.
Then go to small claims court, have your day, and hope you have enough proof to prove your case.
But you were talking about a judgment earlier. I mean, even though he gets a judgment, doesn't necessarily mean I'm going to get paid, right?
Then you have to take steps to enforce the judgment. Then you have to get him in a deposition and try to get the assets disclosed.
Okay. All right. I just be dealing with this. I'm trying to get some kind of. And what about lost time off of work or whatever? Can I actually claim that? Because I mean, I've given up small jobs there to go up there because he won't answer his phone, won't return calls, and said I've been doing.
Yeah, you're probably not going to be able to recover that too much, but.
Okay. Well, figure that.
All right, Matt.
Okay.
Well, I wish you well.
Thank you.
Thank you. Let's go to Jerry in Bradenton. Hey, Jerry. All right, Jerry, are you there? Jerry had a question about a living trust.
Oh, this is Kerry.
Kerry?
Yeah.
Okay.
Yeah, 20 years ago, my dad did a trust, a revocable trust in Arizona. And since that time, the attorney has retired, and we've liquidated all assets in Arizona and live in Florida. And my dad hasn't changed the trust yet. And do you foresee any problems if he doesn't do that?
Did he buy a house in Florida?
Yes, we have property in Florida, liquidated everything in Arizona.
Did he buy the house into the name of the trust in Florida?
Yes.
Well, one state will accept another state's laws. The difference in Colorado and Florida is Colorado is a community property state, and Florida is a common law state. And the trust probably says it's governed by the laws of the state of Colorado.
That's Arizona.
Arizona? Okay. So it would be better to have just a simple amendment done to the trust to say it's governed by the laws of Florida. That's going to make your job a lot easier when the time comes.
I see.
And it doesn't, we charge like $125 to do an amendment. It doesn't cost very much to change a trust with an amendment. Okay. And also, I'm not sure about the will. There are differences in wills, how you prepare wills in different states, and your dad should definitely give you a durable power of attorney. So there's some things, and they're very hard for people to accept those in Florida when they're done in another state, and they should be updated every 3 or 4 years. So
yeah, that's what I've been trying to tell him. My mom was the primary on that trust, and she's passed away. So I was the secondary. It's just me and him.
Well, Jerry, all I can tell you is that we don't charge anything to bring him in to review, to have a discussion. There's like no cost there, and we could tell him these things face to face, and I'm sure he'd probably, if you can get him to the office, I'm sure he'd probably do them.
Okay. Well, thank you very much.
All right, thank you.
Bye.
All right, phone lines are open. You're listening to Ask an Attorney. That's me, Attorney Joe Pippen, all about Florida law. And if you have a question or something you're concerned about, something maybe you lost a little sleep on last night, something I can help you with, talk to you about, just having someone to talk to about a problem sometimes is helpful. You have a toll-free number at 877-943-9673. That's 877-943-9673. Phone lines are open. Let's go to Stacy in Tampa.
Hi, Joe.
Hey, how are you?
Good. My mom passed away in February of this year, and the way she did her trust seemed to be pretty ironclad. She made a few mistakes along the way. She allowed a young woman to be her trustee of the trust who was not family and had no personal interest in the trust. Other than the young lady's mom convinced her she became the trustee, that my mom had liquid money assets that she could take, get such a percentage of for doing the trust.
Right.
The attorney that my mom, when she redid the trust after my father died, was also under the impression that my mother had assets of liquid cash. as it turns out, my mom was a great storyteller, and at 86 years old, she died with $884 in her checking account that my son had became joint on because my mom was unable to take care of her affairs. Everything else was in the trust as far as what to do, and my son and my two sons did an addendum after the trust, a beneficiary agreement, or an agreement among beneficiaries to settle the property that she had, the house that was paid off, the car and furniture and just stuff like that. Now the trustee is asking us as the family to pay for the trust attorney.
Mm-hmm.
When my sons tried to talk to the trust attorney, or I did, we were informed she wasn't our attorney, she was the trustee's attorney.
Right.
Now there's no money for the trustee to get paid because there never was, and there's no money to pay this trust attorney that this young girl hired.
Mm-hmm. Well, I don't think the family is responsible to pay the attorney.
Well, I didn't either, and that's what I told my sons, and I'm not in the trust because of the way that she did the trust. It was an agreement that we did for my children.
No, the attorney can only have one client, and the clients, if signed a fee agreement, then that client is responsible for the expenses, and I don't believe that person can go against the family unless you just want to be nice guys and volunteer. I don't think you have any obligation to pay.
No, because she just sent my sons a letter, the trustee did, a personal letter, stating that they owed her $5,000 for her time, and my 26-year-old
No,
what do I do with it?
Yeah, the attorney, the son can get an attorney to write a response letter that they're not responsible.
Yeah, that's what I told him to do, but I just found it odd that we're dealing with a 34-year-old female who was talked into being somebody's trustee thinking the woman had money and there was no money.
Well, listen, you also don't know the honesty of the trustee we're dealing with here. So one way to verify kind of things is to get a copy of the last tax return.
Right.
That's going to show the income, interest, and dividends should have been reported, and that way you'll know whether you're getting a true picture of the financial assets.
Yeah, we got all the taxes for the previous years, and in the last year, that's when my son moved in with her. She had money that my father and her put up over the years, and in my father died in November of 15, and from November of 15 until my son moved in September of 16, my mom pretty much blew through money like it was a party.
Yeah.
She went to Biloxi with 6 of her friends and had quite a time. So in the end, there really, honestly, was no money left.
All right, Stacey.
All right, but
well, I hope I helped you. All right, thanks.
Thank you a lot.
All right, bye-bye. All right, let's go to Jesse.
Hey, how are you?
Good.
So my wife and I, my family, moved into a home about a year ago. The landlord at the time had staged the house with some furniture. Then he said if we wanted to keep any of the furniture in the home, it was fine, and then we could just leave it when we moved out. Well, the house just got auctioned off for foreclosure, and unbeknownst to us, and we just got our 30-day vacate notice from the bank, and we worked out a cash for keys deal. But now I got this old landlord kind of throwing legal mumbo-jumbo at me, telling me that I need to give him his property and the keys and this, that, and the other thing. My question is, does he have any legal recourse against us? Because I don't want him in the home. I don't want him near the house. The bank told me not to deal with him anymore, so I want to know the stuff that he's left in there. Did he lose that in the foreclosure process, or does he have a legal way of coming after me after I move out if that stuff isn't returned to him? Because I have to move all this stuff out in order to get the cash for keys so we can move and all that good stuff.
Yeah, but it's not your items in the house, though.
Well, no, the house wasn't furnished. He left just a couple small things there, and the house is obviously sold to the bank at this point.
Well, the furniture doesn't come with the house, though. Why don't you just give them the items?
No, I don't have a problem giving the items. I just don't want any type of confrontation at the house.
Well, have a police officer there.
Yeah, because it sounds like he wants to come in and take the appliances and everything else.
Just have a private detective service or a police officer. If you can't get a police officer to come be on the scene on possible conflict between you and him, then just get a private security officer with you.
Right. because the bank told us not to talk to him at all anymore, and I feel like, I don't want to do anything wrong.
Well, you could have an attorney write him a letter to arrange a meeting.
Okay.
And a time, so you know exactly what's going to be, and then have whoever there you want to as your security team, basically.
Right, because the bank told me pretty much anything that he left in there at the time of foreclosure, he had plenty of time to come and get it if he wanted it, up until, and now all of a sudden he wants it. He pretty much forfeited all
I think he would cause problems probably if he doesn't get it, so I don't see any reason why you just can't orchestrate him a time to get it. And whatever he is his, maybe just put it on the front sidewalk before he comes. Don't let him in the house.
Okay.
All right, Jesse?
I appreciate it. Thank you.
All right, thanks.
Bye.
Phone lines are open, 877-943-9673. Toll-free number, 877-943-9673. And let's go to Bob in Largo.
Hello, Attorney Pippen.
Yes, sir.
Good morning.
Good morning.
Hey, my wife and I are both going through a divorce, and I have an attorney, and he is excellent, very, very quick. He got a lot done. Her attorney, however, I paid the $7,000 retainer fee back in March, and to make the long story short, he went through the retainer plus an additional $4,000, and the financial disclosure isn't even completed yet.
Mm-hmm.
He has just dragged her along unmercifully, and he's treated her terribly. She cries. When she comes back from his office, she's crying. Nothing has been accomplished. And when he demanded the additional $4,000, I wrote him a letter, explained to him that on his billing statements he had charged 21 hours, and we still didn't have a financial disclosure.
Mm-hmm.
And that I felt that the $7,000 was sufficient. Well, he demanded to be paid by a certain time, and then he took us to small claims court. Well, I was more than willing to support my wife in this, because he is just awful. So
Well, Bob, let me ask you this before you get too deep into this story. You are represented by an attorney, so I'm kind of restricted on what I can advise you to do, even though we're talking about your wife's attorney.
But my attorney is not involved. The small claims court is not against me; it's against her.
Okay, well then,
she won't. She refuses to go to the court. She's afraid of the guy. She said
okay, well here's what's going to happen then. What's going to happen is the attorney that goes to court is going to get a judgment because she doesn't show up.
No, I already paid him. I paid the guy just because she, at the last minute, she said that she wouldn't go. So my attorney said, Bob, at this stage of the game, you're putting bad money against.
Yeah, well, I would agree with your attorney. So what's your question?
Well, what recourse do I have against a lawyer that I think is a thief?
Well, it's your wife.
Is there a professional organization?
You don't have a relationship with this attorney, though. You paid him for your wife's debt. So
no, I don't have a legal association with this attorney.
No, I don't think you have any legal recourse against this attorney yet. I guess, would your wife sign something about the way she was treated? Maybe send a letter to the Florida bar? That's the only thing I can think of. There
would be at least a bit of justice associated with that.
Yeah. That would be something that she would have to sign, though, because you're a third party in the matter. So
well,
she didn't.
I would write it for her because I have that skill.
Okay. Well, that's certainly an option.
And what could they do?
I hate to even mention the Florida bar and writing a complaint letter because I don't know enough details about the matter. If it's serious enough, and don't tell me any more details because I don't.
Okay.
If it's serious enough, they might do an investigation of it.
Gotcha.
All right.
All right.
All right. Thanks, Bob.
It is, I guess.
All right.
Thank you.
Uh-huh. All right. Let's go to Susan in Sarasota.
Good morning, Attorney Joe. You've been very helpful to me over the years. I appreciate your show.
Well, thank you.
You're welcome. I have a question. My husband and I dissolved our marriage 2 years ago almost.
Mm-hmm.
And he remarried in October of 2016.
Mm-hmm.
We have a minor son, and his new wife has a minor child as well. He reopened our marital dissolution case because we were in a foreclosure situation, which has been resolved. But I'm wondering how that will be closed again. Now that he's remarried, I don't want him... I don't know. There's nothing else to settle in my mind, but he was upset with me because I wrote a letter that was inadmissible in court, but it is a public record. And it was just a letter like I've been writing with the foreclosure department over the years, a letter of hardship. And it was just the facts. But he doesn't like the facts, and he doesn't like the facts that are public now because he reopened the case against me.
Well, he didn't reopen the marital case. He did.
The marital dissolution case is reopened, and he did that in March, and it's still open.
But the divorce is still final.
Well, I guess so. I don't know how that works. That's kind of what I'm asking. What's the agreement?
I think he just reopened it as to a financial issue, but not about the marital issue.
Well, no. I mean, I know I'm not married to him. He's married. I'm okay.
Right.
I took my vows. I actually still call him my
He's just making
husband.
a financial claim or an adjustment on the financial decision the court made, basically.
And I don't want that. I don't want him to especially because he's remarried.
So you don't have your own attorney look at this?
We actually did it all pro se before. I had an attorney, actually one that you recommended when we were in the foreclosure process, review the letter that I wrote to the court. Again, it was inadmissible probably because I didn't have the right cover page on it or something. But it had the effect of at least telling the bank where I was standing on this foreclosure issue, and his attorney where I was standing on this foreclosure issue.
Just revisit the matter with that attorney.
Okay.
Because if you don't have final conclusion, you're not satisfied with the answer, or you're unsure about a few things, just have that attorney who's also already been involved in the file.
Okay. Wait, before you go, sir, the minor child is unhappy because his father not only lied about being remarried, but denied when confronted by the minor children. So it was a big emotional blow-up recently. And he's also not paying some bills that he had agreed to pay. So I was told there's maybe a parent coordinator I could contact. In a new legal, the Florida laws are becoming more friendly toward pro se people, and
yeah. Susan, call our office and ask to speak to Catherine. She's the family law attorney, and she can better answer that question than I can.
All right. Thank you so much. Keep doing your good work, sir.
Thank you.
Thank you. Bye-bye.
Let's go to Sue in Tampa.
Good morning, Joe.
Hey, Sue.
I have a quick question. I have a revocable trust, and I also have an LLC. And I was wondering if I should place the LLC in the trust. Is it possible or no?
Yes, you do. What you do is to transfer the membership certificate of the LLC to the trust, just to keep the LLC from going through probate when you pass away.
Okay. I can do it like now while I'm still operating it?
Yeah. While you're still what? Yeah, you have a trust, right? And you have an LLC.
Right.
So you can transfer the membership certificate that you have showing your ownership of the LLC to the trust.
Okay. And then another question. So if something happens, like somebody going to sue me for some problem happened with the rental or something.
They can only sue the LLC because you have a different entity, so they can only sue the LLC.
Even though it's in the trust?
Yes.
Oh, okay.
You have another layer of protection by having the LLC.
Okay, great. So that's good. I have one more question. I don't know if you have time.
Go ahead.
Okay, it's for my friend though. Her tenant, one of her tenants, has filed a bankruptcy, and he pays a lot of money for his staying there, like $4,200 a month is his rent, and he wrote a letter through a court asking my friend if she will continue with him on the lease, and that will protect him from the other creditors and his estate if she is willing to let him stay at her place. But she's thinking maybe he needs to go to a place that's cheaper for him so he can pay his debt to other people. So she's to respond in about 14 days to this letter to the court why she should not allow him to stay or allow him. Her question was, can she willingly break the lease for him so he could go to another place, even though she gets paid a lot of money?
She's the landlord?
She's the landlord.
Well, upon agreement, she can terminate the lease with him. He doesn't want to break it.
No, he wants to stay in that big house.
No, she can't terminate it one-sided, no.
Oh, okay.
She can't unilaterally just terminate it for that reason. There might be some other reasons it could be terminated, but not for that.
But the court...
Yeah, Sue, I've got to move on here. I've got other questions, so hope I helped your friend, though.
Okay, thank you.
Thank you. All right, let's go to Paul in Jacksonville.
Good morning, Joe.
Hey,
Thank
Paul.
you.
Mm-hmm.
I have my concern is I had a cousin that died about a year and a half ago, and he chose a third cousin as the trustee. And it was a long, drawn-out process. He had $1.8 million. He gave a third of it to charities, and the rest of it he divided among 19 individuals. My brother was very upset about how this was done because...
about the choice of the trustee?
Yes, not only that, but the choice of attorney the trustee picked.
Well, he's not going to have any say about any of those two issues.
Okay, well, the thing that made it...
Well, tell him to get over it.
I tried that, but I wanted to get your
well,
thoughts
no, I mean, you can't just be upset about an attorney or a trustee. I mean, you can be upset with the work they do or something unethical or improper or a bad decision they make, but you can't be mad about the choices of the people itself. I mean, you can be, but it's not going to do any good.
So the trustee choosing his brother-in-law to be as the attorney, it was not an issue.
No, I don't think so. Not as long as they both properly do their job and get proper accountings, and they make prudent decisions. They have a duty to be a prudent trustee.
Mm-hmm.
They can't do any self-serving acts. They can't benefit themselves. And as long as they're doing a good job and giving a proper accounting of everything, I don't think there's a whole lot you can usually complain about.
Well, is there a guideline on what percentage of the estate or something like this that the attorney gets paid or the trustee pays himself?
There's a statutory guideline on attorney fees for attorneys representing a trust.
Uh-huh.
And the statute says like 2.25%.
Okay.
And then the trustee's entitled to a fee, which is usually 1 to 1.5%.
Is this the same all over, or is this very?
That's Florida stat. It varies from state to state.
Okay, I'll have to find out what it is for Kentucky then.
Yeah, well, hire an attorney to represent, write letters, demand accountings, explain things. I mean, that's also a choice.
Okay, thank you very much, Joe.
All right, thank you. All right, you're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. We're here every week during this time period. If you would like to contact us, our toll-free office number is 1-800-226-3529, 1-800-226-3529. If you'd like that free estate planning poster sheet, you can get that one of three ways. You can email me and request it. I need your name and address at Joe, attypip.com. You can call our toll-free number, 1-800-226-3529, extension 200. You can text me your name and address, 727-667-3967. And be glad to get that out. It's a full-size poster sheet all about estate planning. Talks about wills, your options on wills, trust, probate, guardianship, power of attorneys. Has all of our contact information, all of our office locations on one side. And our webpage also has the radio show information. And soon to be, we'll be on a television network coming up next week, live streaming. Tell you all about that next week. Hey, you have a safe weekend. So long. Thanks for listening.